This lesson is going to concern itself with the issue of forfeiture when it comes to the termination of a leasehold agreement. We focused on all of the other different ways and methods by which you can terminate a lease agreement in the previous lesson, including things like merger, repudiatory breach, the notice to quit, termination, at least the an end of a leasehold agreement, the end of an agreement whereby the duration has elapsed, all these different kinds of things. But forfeiture was one that I said was legally and logistically a little bit more complicated, and so really merits its own video in and of itself. Now, this is actually our final lesson on the subject of leases, and we are going to spend some time, like I said, talking about this concept of forfeiture. So let's just begin with asking the very simple question, what is forfeiture? Forfeiture is a remedy that is available to a landlord for the breach of a covenant in a leasehold agreement by a tenant. Simple as that, really. It will lead to the termination of the lease, and often it will also lead to the eviction of the tenants from the property for which they had previously been renting from. There are a number of steps which are required for a landlord before they are able to instigate the process of forfeiture. So they can't just press a big button, the forfeiture button, and then the high court enforcement agents then come along and evict the person in question. Instead, there are steps and stages that they should go through, and there are also remedies from forfeiture that a tenant can actually go about to try and essentially allow for them to either stay in the property or to get some kind of financial compensation for their eviction. It also concerns the type of covenant that is breached. So there are really two different types of covenant for which there are two different procedures of forfeiture. The first is for the non-payment of rent. That is the first type of covenant, and is one that is almost universal for every and any single type of leasehold agreement. Almost every single lease or renting situation will involve the payment of rent. Simple as that, really. The second type of covenant that can be breached is any other covenant. So the courts and the law delineates the idea of non-payment of rent separate to that of any other kind of covenant and any other kind of agreement. Couple of points of note to begin with then. So the landlord can waive their right to forfeiture in certain circumstances, which means that if they in the future decide to come and try and instigate a process of forfeiture, they will fail in that aim, in that goal. If they have knowledge of the breach, for example, but they do some act which recognizes the continuation of the lease, this will cause them to have waived their rights to forfeiture or for a particular breach, because it essentially implies that the breach in question was not severe enough to warrant the termination of the lease, at least in the eyes and the intent of the landlord. So if they knew about the breach of the covenant, but they then recognized the continuation of the leasehold agreement, then they waive their right to forfeiture. Because theoretically, what the point of forfeiture is as soon as a breach of a covenant for which merits forfeiture takes place, the leasehold has been terminated. So if they know about a breach of a covenant and they recognise that the lease still exists and it still continues to exist, then that therefore represents a lack of termination of forfeiture. If the lease in question is a residential property and is being used specifically for residential purposes, then the landlord has to go through the process of the Protection from Eviction Act of 1977. This will involve getting a court order for eviction in accordance with Section 2 of that legislation. Specifically then, when we think about forfeiture for non-payment of rent, this is the most common type of forfeiture which takes place, given the fact that it is the most consistent type of covenant that exists within any kind of leasehold agreement for which there can be a forfeiture and a termination of the leasehold agreement, and so as a result of which the non-payment of rent is the most common type. The first demand and the first requirement is the formal demand of rent on the day that it is due. If this is not satisfied, then there is the opportunity for forfeiture. The landlord must then acquire a court order if the property is commercial. Simple as that, really. When it comes to other kinds of breaches, other kinds of covenants, if there is a desire for forfeiture on account of a breach of a covenant which does not concern the non-payment of rent, then there will be a requirement for the landlord to serve notice under Section 146 of the 1925 Law of Property Act. This is sometimes known as a Section 146 LPA notice. The Law of Property Act says the following in relation to Section 146. They say, quote, a right of re-entry or forfeiture under any provision or stipulation in a lease for a breach of any covenant or condition in the lease shall not be enforceable by action or otherwise unless the lessor serves the lessee a notice specifying the particular breach complained of, and if the breach is capable of remedy, requiring the lessee to remedy the breach, and in any case requiring the lessee to pay compensation in money for the breach. So this actually allows for the existence of a remedy away from forfeiture itself. So if you have a breach of a covenant that is not the non-payment of rent, that is a separate issue. But when it comes to any other kind of breach of covenant, you should send them a Section 146 notice. And then that notice shall specify the breach in question, specify if there is any remedy for that breach that could essentially save the tenancy agreement, and then in any case, in any situation, there would be a requirement for the lessee to pay some kind of compensation in money for said breach. The landlord will often be required to allow time for the notice to be complied with, if possible. So if there is a compliance requirement here that essentially allows for the tenant to do and perform some action that will essentially save the leasehold agreement and deal with the covenant breach nice and easily, then there should be time allowed for this notice to be complied with. Bear in mind, again, the process of getting a Section 146 notice or the process of getting a court order under the Protection from Eviction Act and actually getting an eviction to take place is all a process that a landlord is likely not going to want to have to deal with. So if there is a breach of a covenant for which there is a potential remedy, they're probably just going to send a letter to the tenants and say, look, please just deal with this remedy. We'll give you time to comply with this notice. I don't want to evict you. Please, let's just get and deal with this problem. Because obviously it's a headache for everybody involved for there to be an eviction. It's only in the extreme circumstances that they will go with a proper eviction process. If there is available remedy, then this will usually amount to 3 months' notice. So 3 months' time at least allowed for that notice to be complied with. Quite a significant amount. And is also, in fact, been confirmed in the case of Expert Closing and Hillergate House Limited from 1986. If there is not a remedy, then you may have a compliance requirement of 14 days, as per Scalar House District versus Forbes from 1974. So given all these facts, you might think that this is seemingly particularly strong in terms of the kind of power that a landlord may have over a tenant, and in some circumstances it is. However, there is relief from forfeiture. There is the ability for there to be relief from forfeiture, which essentially protects a tenant against the strongest claims of forfeiture, or at least if there is the requirement of a breach of a covenant, or if there is a breach of a covenant, let's say, that there could be relief by way of remedying that situation, which does not necessarily result in a forfeiture agreement. So these are essentially the steps that a tenant is able to take in order to remedy the forfeiture and therefore allow them to stay inside the property. For cases that involve the non-payment of rent, relief from forfeiture is actually quite simple. It is just pay your rent, pay the arrears that you are in, and if this is done before the court order is executed, then the relief will be successful, and there is no recourse for the landlord to kick you out and for there to be an eviction. If not, applications may be entertained up to 6 months after the issuance of a court order, which could then also give you relief from forfeiture. When it comes to breaches of covenants that do not involve the non-payment of rent, then the relief can be issued up to the repossession of the property itself. It will generally be up to the discretion of the court as to whether or not the relief from forfeiture has been successful. Generally speaking, if there is a compliance with good faith and a compliance in good faith in any of these cases, often it will be the case that relief be successful. Obviously, unless we're talking about the quite severe breaches of covenants or the severe non-payment of rent to which people are in ridiculous amounts of arrears. But if there is generally the charitable the charitable and good faith compliance with the court order or with the threat of a court order with a Section 146 notice, then there will often be a successful relief from forfeiture. But obviously, these things are dependent on a case by case basis.